pre-authorization to foreclose on Hawthorne Lakes PUDs in Frankfort Township. The letter of credit isn't set to expire until November, but we are, as customary as we have done in the past, just trying to be out in front of any need to foreclose. We don't see an immediate need, but we're just trying to cover all of our bases.
Any questions? I have a motion to approve. Motion, second. All in favor say aye.
Aye.
Any opposed? Motion carries. Next item is reimbursement for drain funds Moonlight Estates.
Yeah, thank you. This is Moonlight Estates in Ordinance Township. We had foreclosed on the project. We had utilized those funds were deposited in the treasurer's office, and we had since then completed the public improvements that were necessary, that were initially approved. The remaining balance on this project is $146.52. There's an invoice from the Land Use Department for administrative and engineering work that we had conducted to finish the improvements. So we're requesting that the approval of returning or the payment to the Land Use Department of that amount for reimbursement.
Any questions? Motion, second. All in favor say aye.
Aye.
Any opposed? Motion carries. The next item, another reimbursement steeplechase.
Same scenario. This is also in the Knox Township. We had completed the improvements and we had remaining funds left. In this instance, we're requesting two payments being made of the remaining dollars. One to the Land Use Department for administrative and engineering fees in the amount of $2,634.20. The other payment being made back to the issuer of the letter of credit, TCF National Bank, in the amount of $12,913.20.
Any questions? Motion, second. There is one correction on the letter of the date of approval of the piece of aid. So all in favor say aye.
Aye.
Any opposed? Motion carries. Next item, the Stormwater Planning Committee, Subcommittee.
I'm taking that one too, thank you. This is I need the Stormwater Management Committee. Their representation districts mirror the county boards. And with the county board changing their districts from 9 to 13, as you all are aware, the Stormwater Committee must do the same. This change is embedded within the Code of Ordinances for the county. So based on our state's attorney's consultation, we have to make that revision. So this revision is effectuating that district changes from 9 to 13. No action is needed today from the committee. This is simply a information only. We plan to bring this back to land use next month for a public hearing, which is required to make the ordinance change, and then ultimately county board for approval.
Any questions by committee? Okay, we'll wait until next month. All right, Reed.
Just a little where you went so fast on it, Mr. Chairman. Back to the Hawthorne thing, just one point, a little technical thing. The first line of that letter with Hawthorne, sir, you have a misspelling with statues instead of statutes. Just wanted to point that out.
Okay.
So
Thank
that
you.
perfect letter.
Thank you.
All right, thanks.
Okay. So we'll go back to new business. Back to new business, case 6117S, special use permit for sports and recreation.
Thank you, Chairman Weigel. As you stated, the applicant is requesting a special use permit for sports and recreation. It will allow for an indoor soccer practice facility to continue operating on the site. This special use permit request is a result of a citation that the Land Use Department issued. The use commenced without the special use permit. Staff and the Planning and Zoning Commission recommend approval of the special use permit with 9 conditions. There are no objectors at that public hearing. One reason why special use permits are required for this type of use in industrial properties is that oftentimes industrial properties were not developed with the intent for an assembly use to occur. So a lot of times there's concerns with the existing well and septic, with building code, fire code, and parking on the property. The 9 conditions are designed to address those concerns, and again, staff and the Planning and Zoning Commission recommend approval.
Any questions by committee? So moved. We have a motion, second. Any objectors to this change? Okay, all in favor say aye. Any opposed? Motion carried. Next case. Mr. Ballard, you had a question?
Mr. Chairman, you didn't see me raise my hand before. Under item K, discussion of use of aerial photography in code enforcement operations, I'd like to have that brought forward again next month because I'll have something to present next month.
You don't want to have it discussed today?
Oh, we could discuss it today, yeah. I thought you skipped it over.
No, we're going back to that.
Okay. I'm sorry, I didn't hear you.
Okay. Okay, the next case, 6119S, special use permit for craft brewing and distilling.
Thank you, Chairman Weigel. As you stated, the applicant is requesting a special use permit for craft brewing and distilling. The property this committee would probably recognize it as CD&Me. It's on Route 45, the northern part of Green Garden Township. Staff and the Planning and Zoning Commission recommended approval of the special use permit with 3 conditions. The Green Garden Township Planning Commission reviewed, voted not to object to the special use permit on September 3rd, 2013. The Township Board met last night. I have not received official correspondence from the Township Board. I know the applicants are here, and I'm sure they're at the meeting. They can speak to the outcome at the township level last night. The property currently holds a valid liquor license. The property is also used right now as a banquet facility, landscape business, concert venue, comedy club, and courthouse. Now, the Village of Frankfort submitted a letter. It's not a letter of objection, but the village does have concerns with the amount of uses that are taking place on the property. They wanted to see some stipulations that encourage improvements to the property. One such improvement would be roadway improvements to accommodate the traffic. Route 45 is under the jurisdiction of the Illinois Department of Transportation. The county has no authority over that right-of-way. IDOT has been notified of not only this special use permit request, but all the other permits the county has issued to this property. At no times has IDOT required any right-of-way improvements.
Okay, any questions by committee?
Did they bring samples? I was going to ask that. They brought samples. They better be cold. I do have a serious question. What is the zoning currently on that?
Property is currently zoned C2 with a special use permit for the sale of
Does
liquor,
the
banquet
distillery
facility.
change that at all?
It does not.
And there's no, nothing being grown on site or anything like that? It's all purchased?
I would defer to the applicants to answer that question.
Okay. Sounds like a vineyard or something. No, that's fine.
Any other questions? Did you say the township was here? Or?
No, but the applicants are here and they attended the township meeting last night.
What did happen at the township meeting?
The applicant here, would you like to come forward to the podium? State your name and address, please.
My name is Dean Vondre, co-owner of CD&B and Gervais Outdoor Creations. The address is 23320 South Grange Road, Frankfort. We were at the meeting last night and there were no objections. No one in the audience objected and the board voted 5-0 in favor.
Thank you. Any other questions? Is there any objectors here? No objectors. Okay, motion to approve.
Second.
Motion, second. All in favor say aye. Aye. Any opposed? Motion carries. Thank you.
Thank you very much.
Next case, 6121M, is for staff amendment from E2 to R2.
Thank you, Chairman Weigel. As you stated, the applicant is requesting a map amendment from E2 to R2. This will allow for a 2-lot subdivision. Staff, the Will County Planning and Zoning Commission, and Green Garden Township recommends approval of the map amendment. Staff's recommendation of approval is based on the fact that there are over 400 acres of R2 zoning within a half mile of the subject property.
Any questions by committee? A motion to approve? Second. Any objectors? No objectors, all in favor say aye. Any opposed? Motion carries. Okay, moving on to other business, major waiver of the subdivision ordinance.
I'll be handling that, Chairman Weigel. This is related to the zoning case that was just voted on. Again, it's a map amendment from E2 to R2 so that they can conduct a two-lot subdivision. The Will County subdivision ordinance requires hookup to sewer and water if the sewer and water is available within a quarter mile of the property. Sewer and water is available within this property. The applicants are requesting a waiver because to connect the subdivision to that sewer and water, they would have to run it a significant distance down a county road and then go underneath county right-of-way. They would be serving one lot of the subdivision. It's a two-lot subdivision. Only one lot will be built upon. The other lot is already improved, and the house is already served by a well and septic.
Any questions by committee?
Motion.
Motion. And second. All in favor say aye.
Aye.
Any opposed? Motion carries. Next item is structure survey.
Thank you. This is the, we went out for bid for the Peatone Rural Structure Survey, and as you may recall, we received a grant. We knew that the grant would not cover the entire township, so we structured the bid so that it would be bid on in two different parts, part 1 and part 2. The CLG grant for 2013 is enough to cover part 1 of Peatone Township. We had one bidder, with Jenny. They have done all of our other rural structure surveys that we've been doing over the past 14 years, I believe. So this is just to move forward with awarding them the bid for Peatone Township. And then next month, the state has come out with their new round of CLG grants. So I'm going to be bringing forward a grant application next month to apply for a grant to complete part 2 of Peatone Township.
Any questions by committee? We have a motion to approve.
Motion.
Motion. Second. All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. Okay, moving on to aerial photography. Last month we had tabled that case, and I think Mr. Howard had some questions about the cost that we spent over the past several years on this. We have a motion to remove it from the table.
Second.
And a second. All in favor say aye.
Aye.
Any opposed? Motion carried. Okay, Pat, you have answers?
Right. What I'll try and share with you are answers to the questions raised by Mr. Howard. I think part of the way to do that is to distribute a copy of the board's minutes from January 17th of this year. In addition to this, Tong, who's the director of the GIS department, is with us today, who actually oversees the contract that was authorized by this board motion, and he can tell you other details about the actual contract that this authorized, as well as what expenditures to date are. But you'll note in the highlighted portions that on the 17th of January of this year, Resolution 13-02, a resolution was put forward regarding aerial and oblique imagery project. The purpose of this particular resolution was to authorize the county executive to enter into an agreement with a firm called Pictometry International Corporation for 3 flights from 2007, for 2013, 2015, 2017. And this was for both regular aerial photography as well as oblique photography for an amount not to exceed $866,446.50. I think the point here is that in the resolution it described what the purpose of engaging in this particular contract would be. I've highlighted that for you, that it's to support the decision-making process for many important issues currently facing Will County, and then it enumerates several, but mentions amongst those land use, which would incorporate code enforcement activities. And then you'll note that this particular motion was made under the report of the Land Use Committee, so the entire resolution, of course, had been vetted by this committee prior to it going to the board. So as is usual practice, the chairman, in making his report, made the motion for the adoption of this particular resolution, and it happened to be seconded by County Board Member Steve Bolish. Then the vote on it was unanimous of all those in attendance. So I think that answers most of the questions, I think, that were posed by Mr. Howard. If I missed anything, Mr. Howard, please ask me. But this is the entity that was authorized to contract with the county. This was for what purpose? This was for how many flights? And this was how much it was going to cost. Now, Mr. Tong can indicate to you, after this contract was authorized and executed, how much has already been spent and how much of the photography that was authorized with this resolution has already occurred.
Any more questions?
You answered my question.
Okay.
Thank you.
Would it be helpful to have Tong share with you how much has been spent thus far under this contract?
Yes. Okay, Mr. Tom.
Good morning, committee members. Basically, we contract 3 flights over 6 years, so the flight is every other year. So the first flight actually completed this year, and the total cost for the first flight is $269,488, and we divide the payments into 2 because it's every other year. So for this year, we pay half of that amount, which is $133,514. So that's what we paid so far, and the other $133,514 will be paid next year.
Tong, could you perhaps describe the scope and nature of the photography that the contract undertook?
The contract actually includes the flight. They will capture both aerial photography, which is we call the regular aerial photography. Basically, it's a 2D imagery. You see the rooftops, and it also captured the oblique imagery, which is 3D imagery. So the flight will capture these 2 kind of imagery for the county, and those imagery, the traditional, the regular aerial imagery is used by many county departments, and the oblique imageries right now is mainly used by 911 and SOA and some other departments. So,
did this cover the entirety of the county?
yeah, it's covered the whole county, and also we go beyond, I believe it's like 1 mile out, outside the county boundary.
Question?
I have a question on the mechanics of it. Basically, that's a fixed wing aircraft that flies, and it just flies like in a pattern, back and forth. Is that what it does, or how?
Yeah, they usually, I'm not really sure how they do it, but based on what my understanding, they usually based on either north-south or east-west. They just go back and forth to fly, and then cover the whole county.
How long does that take generally?
The flight usually, if it depends on weather. So if the weather good, it probably take 2-3 days to will finish. Yeah.
And then when you say that it's 3D imagery,
Yeah.
Can you explain that to me, how that actually works?
Basically, if you look at the regular, if you go to Google Map, you only see the rooftops.
Okay.
And the 3D one, you can see the facade of the building, you can see the windows, the doors, any signs on the building. So, and it's 4 directions.
So what you're saying is that if it flies over your home, they'll not only see the rooftop, but you'll also see all four sides of the home?
Yes, for the oblique imagery, yes, they can see the four sides, where the windows and the doors. I mean, that's why the 911 is especially interesting, because they want to see those entrances, when emergency happens.
This term oblique, as we know, refers to an angular
Yeah.
shot. That's what the word oblique means. I don't know that it would be correct to describe it as 3D imagery. It's angular imagery. And that is something relatively new. The straight down type of aerial survey imagery, Tom, perhaps you don't know, but we're talking about the contract for this year and the coming several years. How long has the county been taking aerial photographs of the direct vertical type?
I came to the county in 2007, so what I know is the county actually had a flight back in 2004. The whole county. Then we did an update, which is part of the county, in 2006. And then from 2007 to 2012, we actually also contracted with photometry to get both the aerial and the regular and also the oblique imagery. But at that time, 911 is the department to manage the contract.
I would just mention to the committee that the county has done aerial photography that used to not be embodied in the GIS, but was in what was called Stillwell maps going back for decades. For decades, aerial photography of this vertical type has been undertaken by the county.
A couple of additional questions. So you probably do it in the fall or when the leaves are gone?
Usually we're doing the spring, yeah.
Okay, so
when the leaves are off.
foliage or whatever
Yeah.
to get in your way.
Yeah.
Is it possible to get an example of that? Not right now or anything, but in the future. I'd like to see that. That's kind of neat. It sounds like. So
Yeah, I can send you some.
just an example.
Yeah.
The oblique is what you call it. So.
Yeah.
Right. Thank you very much.
Mr. Howard, if you'd like, we could have it up in about 2 minutes.
Wow.
You had a question, Mike?
Not a question, but a comment more. I don't think, all the information that Mr. Pat has brought up is not really relevant to what my counterpart, Mr. Balich, his question of this group here. I don't think Mr. Balich ever said that we shouldn't take photographs. We're talking about how the photographs are used. And yes, Steve did second that we should take photographs, as we all do. No problem with that. I think what we've got to get to the heart of the issue is, especially how it pertains to land use, how are those photos used? Are they used to initiate code enforcement? Are they used as against someone coming to adjudication without them to be able to retort any information that's brought because of a picture? I think that's the key issue. Raymond, maybe you have some things that you can.
Thank you. Since our last meeting, I actually was able to get some information that from the land use department that I think I had passed on to some of you, which was a document titled the Will County's Code Enforcement Policies and Procedures Manual. And that's where I was hoping to get some of these answers on, but nowhere in this document says who the author is, how this document was even, how it even came about, and also there's no reference to the aerial photographs as to how and when they're used. So I think that's maybe a starting point where us as a committee can take a closer look at that manual and maybe start from there as to what exactly are the policies and procedures, because it seems that they have them for the code enforcement, but again, nowhere in there it says anything about the aerial photographs. So I don't know if that's something we want to look at.
Or if it's best that we separate the two issues, from the taking of the photographs to how the photographs are used.
Yeah, I don't think anybody had a question about taking, I mean, Mr. Howard's question was just about how it happened. No one was saying that they were against taking photographs, including Board Member Balich. I mean, that was never really mentioned. This was more information, right, Rob? So that's how it happens. That's great that we took the photos and we all approved that, and so did the whole board. I think as it pertains to this committee is how are we using those photos for land use and code enforcement?
An additional comment on it. That originally, when it was brought forth to us last time, it was almost like, do you want aerial photography, yes or no? And that's the way I perceived it, and that's not truly the question here. The question is, again, the policy and procedure of the actual utilization of the photograph. But I'm curious about looking at the photographs. The process is very interesting. Thank you.
Any other questions? Mr. Ballard, do you have any comment?
Yes, next month I plan on bringing something forward to land use. I'm working on it right now. But I concur with what Mike said. You know, I'm not against the actual taking of the pictures. I'm against what in my opinion is the overreaching use of the pictures. So there's two, it's distinctly different. You know, the pictures themselves aren't the problem. The problem is what happens with the pictures.
Okay. I guess we need to continue this in the next month. Mr. Paddock, she referenced the procedure manual. Maybe you could provide that for everybody.
I believe that it was forwarded to county board staff for distribution to all members, but we'll see that it's done again.
I don't think they have.
Mr. Chairman, when I asked the question last month, if we have a complaint-driven land use department, if you will, and with regards to the photography, I asked how they use those essentially, and it was said that they drive up to the house or what have you, and I didn't get the impression that they're using the aerial photography as, okay, we're going to go check now. Mr. and Mrs. Smith call up on their neighbor Joneses, and they don't look at the aerial photography. They go out and go see that if there's a problem with Joneses, if you will, in this particular instance. So,
Mr. Waiver, would you like me to respond to my staff's comments? I think Ms. Freitag has brought up a potentially fruitful approach to this matter. The document that she refers to is an internal administrative document for the guidance of staff. And just like many administrative departments would develop internal operational manuals, this is what this particular document is. But she is quite correct that the matters that I testified to last time, along with my colleagues Elizabeth Dunn and Ron Pullman, as to how in fact we currently utilize aerial photography in conjunction with code enforcement is not presently stipulated in that particular internal administrative document. If there would be I think it makes good sense that, we're a government that's not based upon the current incumbents in a particular role, so that if somebody says, well, yeah, this is what we do, you don't have any particular assurance that if there's new people the next day that they'll remember what you did. That's why you memorialize things in writing. So I think it would be potentially extremely productive that we would revise that internal procedural document to stipulate those things which I described to you, which constitute our current use of aerial photography, which, as I mentioned, is very limited. Now, if after getting that specification down on paper and into that procedural manual, it might still be the case that what we have stipulated as being our particular approach and method and use and so on is not in keeping with the policy objectives of one or more members of the board. In which case, if that is the goal and the objective, what really truly needs to be done is pretty much what Mr. Weigel had pointed out last time, is that someone needs to put that objective into legislative language, not memoranda, not just talking points, but into actual legislative language that would amend an existing ordinance or adopt a new ordinance, obtaining the outcome that that particular policy perspective would wish to achieve. So, I leave that in the hands of the board, but I can tell you in the meantime, I think, as I mentioned, Board Member Freitag has made a very positive observation and suggestion, is that we will right away update our internal procedural manual to reflect the kinds of policies, procedures, practices that were outlined to you by staff at our last meeting.
Mr. Weigel?
Yes.
Thank you, Kurt. It seems like Kurt's in agreement with the same things I'm saying now, that we just need to address it within a legislative document, which right now is being worked on and it will be ready for October.
Okay, thank you. Mike, did you have some pictures you want to show us? Or?
I do. This is the oblique pictometry that was discussed earlier. This is through our Supervisor of Assessments website. As you can see with that aerial photo display, you can see the side walls of the homes, not just the rooftops. And that is what oblique photography is.
Is that your house with a pool? Because I'll be there.
It's not.
So you use that to look at the egress, basically, is what you're doing? Not the 911 actually uses this? So somebody mentioned that earlier.
The land use department is typically, for code enforcement purposes, does not tend to use the oblique photography. They tend to use the vertical imagery. This is the oblique.
And the vertical is accessible through Google Earth anyway.
Well, certainly this is too. I think that you make the distinction for you, and Tom can chime in if he's still here. Over a period of over a decade, the county board has authorized the expenditure of millions of dollars to create a GIS system. The GIS system is founded on aerial photography of all of the geography of Will County, and then imposes various informational layers over that to aid and assist decision-making. Now, is aerial photography of either a vertical or oblique nature available outside of that photography that's within the Will County GIS system? Most certainly. It's available to every 13-year-old boy who's got a computer. But in terms of what this county has direct control over and ownership and the prerogative to somewhat affect its use, this is what you have. Now, the general public, should they choose to access the county's GIS system within certain constraints, which again Tom could speak more knowledgeably to, they can access the same information.
I think we've had a breakthrough here today, and I think that Board Member Freitag has been the one to find the path for us here. I think before we were conflating two different concepts here, and that was the method by which we are getting information about violations of code and the legalities of it. And I think that some were interpreting these methods as being possibly illegal, which I'm not one who subscribed to that theory, with the potential use of this evidence. And I think we're clarifying that these pieces of evidence that were photographic in nature were being obtained legally because open air has been well established all the way from the Supreme Court that these are lawful methods. I think the issue was what use are we putting these photographic pieces of evidence to? And I think that Reagan Freitag made a very good point about the current manual that's being used. And that's a good starting point there to revise that as to how we're going to use it and when we're going to use it. And perhaps having some rules about when these photographs are taken and when we're going to use them is something that we should establish through policy and perhaps giving it the force of a county ordinance. So I thank you, Reagan, for coming up with that suggestion between you and Mr. Paddock. I think you put your finger on the problem, and we ought to run with that ball. So I think we've had a real breakthrough here today. I appreciate the two of you putting your heads together on that matter.
I was wondering, did you draft any questions specifically? I know you said you had questions about who's the author, but did you have a list of questions prepared? Because I'm just wondering for next month we can get some of those.
No, I didn't.
Okay.
Well, I jotted down those that you did mention. And certainly, you know, having some introductory paragraph in the document as to whence this came, you know, who wrote this. It will say very clearly this is an administrative document compiled by the authorized management of Will County Land Use Department, and it's based upon our current understanding of laws, rules, and regulations under which we operate. I think that would answer the authorship question. And then we would perhaps have some additional introductory discussion about how we went about compiling this, what the intended scope of the document was. You can talk about that. And then those particular sections that I think have been pointed out is that we would enumerate in writing the same set of policies and practices that were outlined to this committee verbally last time we met with respect to the question of how, when, and to what extent, and under what circumstances, with what rights of appeal, do we utilize as evidence of a violation aerial photography of the type that's been specified to you today. And I just want to caution here that when we put that down, we'll try to be as accurate and as comprehensive and as clear as we possibly can about what we do presently, okay? But remember, this will be an administrative document, and the procedures and practices outlined there may or may not be in conformance with the policy preferences of one or more members of the board. They will simply be a current expression and understanding of the Will County Land Use Department as to what policies, procedures, and practices it is currently undertaking in conformance with all relevant existing laws, rules, and regulations. And then if somebody wants to change that, they're going to have to introduce and get a new law passed.
Does that answer your question?
Yeah, I was actually just wondering if you had questions, but you might be able to.
Okay, we'll bring this back next month for more discussion. That's all we have under other business. As far as reports myself, our October meeting is being moved back one week because of vacations. So instead of October 8th, it'll be October 15th. So I'll make a note of that. I wanted to mention there was a postcard sent out recently about sprinklers. Contact county board members. The building code subcommittee is certainly updating the building code, and that was one of the items that we're going to discuss, but there does not appear to be any interest in putting sprinklers in residential properties. So hopefully that will be put to bed once we do adopt the new ordinances. So that's the only comments that I have. Any comments by committee members?
Mr. Chairman, are you saying that that's probably not going to get out of that subcommittee or that ad hoc committee, the fire sprinkler mandate for new construction?
Well, right now it's in the international code that we need to have sprinklers, and we have to opt out of it. And so we will have to bring that back before the board.
Mr. Chairman, I don't know if it'd be appropriate today or not, but it'd be my feeling that we opt out of requiring sprinklers as a mandated item with regards to international building code. If it's not appropriate today, I will do it next month. If it's more appropriate, that's coming to us next month. Is that?
Well, no, we've got to wait for the subcommittee to make the decision, and then we'll bring it back to this committee and the full board for that.
Can we vote on it today, or would it be more appropriate to do it when we have the item before us?
Mr. Chairman, would you like me to make some observations?
Sure.
Okay. I believe what the chairman is referring to is that as the subcommittee, which is the subcommittee of this committee, has been looking at the question of needed updates, which could be additions or deletions to the existing Will County Building Code. One of the core approaches to undertaking that task is to consider adoption either in its entirety or with amendments, the international code update for, Mike, is it 2009? I'm not sure. Yeah, I believe it's 2009 is what we're moving toward. And it's within that document that if the board were to adopt without local amendment, there is provision for residential sprinkling. But the point is, like every other jurisdiction, if you're using the international code as a model, it is completely, totally, and utterly at the discretion of the local jurisdiction to what extent they keep, retain, or remove any element of the language of that model legislation. So, what the subcommittee is currently doing is looking at a broad array of issues that would then allow them to suggest to this full committee and ultimately the board how to craft an update to the existing building code that might incorporate many of the changes under the new version of the model code, but would recommend deletion or substitution of a provision that made sense for Will County. And I think what the chairman has shared with you is that on this matter of residential sprinklers, there was one type of consideration when there was active consideration being given by the state fire marshal to incorporating, or I should say perhaps mandating, such a provision within statewide rules and regulations. If that had happened, which it has not, he has withdrawn it, but if that had happened, then Will County as a non-home rule county would have probably been constrained to implement that then statewide regulation. But that's no longer in the game. So consequently, the board and through its committee and subcommittee is firmly in the driver's seat on this issue. And if there's no interest in having residential sprinkling, the people that are in control of that are this body. But as to Mr. Adamick's question of when would you act upon this, that's obviously your prerogative, but I think just the procedure that had been established was that all matters pertaining to the building code update were initially referred to the subcommittee. They've been working very hard. They're reaching a critical stage of the development of their recommendations. I think the hope is that by September, at the latest October, their recommendations will be coming forward to this full committee for your vetting, and all the issues pertaining to any possible changes to the building code will be spelled out to the full committee here, and you'll be able to assure yourself that on this particular matter that there is no requirement for residential sprinklers. And then when you take your action, that will go on to the full board, and likely, as they usually do, they'll accept 95% of your recommendations, and certainly if you recommend strongly that no inclusion of residential sprinklers be included, I'm confident that your colleagues will endorse that view.
Any other comments?
I concur with Kurt. I think once we see it come out of building ordinance, the meetings that they're having, and it appears in meetings I've attended, was already opposed to it, when we get that, if they are still opposed to it, we'll be fine. If they're not opposed to it, then it's our job to be opposed at that time if we are. So I don't see.
Any other comments by director?
No, sir.
Any other comments by anyone?
Michael?
Mike?
I would like to just bring up one issue with this committee. When you review the zoning case staff reports, you've probably seen what is referred to as an EchoCat report in that staff report. That is a report done through the Illinois Department of Natural Resources. And that report identifies protected resources that are in the vicinity of the property subject to the zoning case. Last week, the Land Use Department was notified by the Illinois Department of Natural Resources that as part of new state legislation, they will begin assessing a $500 charge to conduct the EchoCat report. Up to this point, it's been free. So the Land Use Department is working with the State's Attorney's Office to review the legislation to determine when the report is needed, if at all. And as soon as we have that information, we'll update the committee.
Who pays for that now? Or, I mean, who bears that cost?
Right now, it's free.
I know, but
Who bears the cost? That would either be the zoning case applicant, pay an additional $500 fee, or the department would pay and be reimbursed by the applicant. Those are all mechanics that we're working with the State's Attorney's Office to determine now.
You're saying now.
yeah.
Now there is no.
There is no
I
fee.
know, but there's obviously a cost to doing anything. They're doing something, I should say.
You know, my belief, it's a database. You punch in the coordinates of the property and it spits out the protected resources. I don't believe there's a lot of work that goes into those reports.
This seems a bit much. More question?
Just for clarification then, this is not the building permit, this is only in cases of...
Right now, the Land Use Department uses EchoCat reports for special use permits, map amendments, and plats of subdivision.
So basically what's being told to the county now is when that applicant comes in, if you feel it's necessary or if the state feels it's necessary, then there'll be an additional $500 charge.
There will be a charge to utilize the EchoCat reporting system. Again, we're looking into, okay, when do we really need to do this report?
Okay, so basically the question to the state's attorney is if you're in charge of requiring it or not. Okay, so the legislation isn't clear that it is required?
It's complicated, and that's why we're working with the State's Attorney's Office.
Like most legal issues, it's always wise to have the attorney review it. We have had ongoing and understanding of when we were required to include it as a part of Will County zoning transactions. But naturally, you think about it one way when it's a costless item. You think about it in a different way when there's going to be a cost. So now that we've been informed that there's a cost, we have asked our legal counsel to look even more carefully with even more scrutiny as to what are those situations where the county is absolutely, unambiguously required to have an EchoCat report. And then we would, of course, want to limit that use of such a report to only those cases that could be clearly said to be required by either the old legislation or any refinement that occurred on the scope of its applicability under the new legislation.
I have an additional question then. Regarding that then, the $500, would it just simply be passed through Will County or would it go directly to the
Well,
state?
this is another question we're looking into, but our best understanding, subject to additional inquiry and interaction with IEPA, is that the county initially would incur the cost, but the way we would reimburse ourselves is by passing that cost on to the applicant. So the bill would come from the state to the county. We would have to front end the cost and then in essence be reimbursing ourselves by incorporating this additional $500 into any other fees that were being imposed for that particular transaction. So this is not happy news, clearly, and I think what Mike wanted to let you know is we are often, thought of for reasons I totally understand that the land use department is imposing these costs or those costs or the other costs. The only costs that we charge are costs that have been told to us by the county board that we must charge for a particular transaction. If this were to go forward and in a given instance, you know, I don't have to have a crystal ball to see an applicant going, you're making me pay all of this stuff and an additional $500 to find out if there's ducks and bunnies next to me? That's what's going to happen. And then the first person they're going to call is you and say, why is your doggone land use department charging this ridiculous fee? So we wanted you to have early warning of us.
Now, with that fee, one last question here. Does that pertain, like, if a developer, does a developer pay $500 per unit or just $500 for the application? And then a single family homeowner is going to pay $500?
That's a very good question. Why don't you speak to that, Mike, about how it would apply where the project was a subdivision versus where the project was, say, the building of a single-family residence?
It's a fee for the overall proposal. So you would take the boundaries of that subdivision and conduct the report. It wouldn't be for each house in that subdivision.
All right, thanks.
Steve, you had a question?
Yeah, you know, I've been doing a lot of investigating. I've been doing a lot of investigating with this whole topic, and I had FOIA JCAR asking them certain questions, and one of the things that I was told, and I have it in writing from, they referred me to Ray A. Ozinger. He's from the Capital Development Division of the state government, because JCAR couldn't answer the questions, and neither could the Attorney General. But anyway, I have it in writing. This says that the state has no means of enforcing any of these mandates that they do to us. And I wanted to find out, in the case that we're talking about now, is that something that the state can enforce, or is it something that they say we must do it, but they have no teeth to make us do it?
Well, the state's attorney will investigate that and tell us, you know, what we have to do or not do. So, if there's no other questions, we have a motion to adjourn. Motion second, all in favor say aye.
Aye.